Hello, my name is Ted Corliss. I'm a lawyer with the Corliss Barfield Trial Group. I'm here today to talk to you about an especially sensitive issue. That's the denial of a life insurance policy when the individual deceased is being accused of committing suicide. You know, during the 20 years that I've been practicing law, both in the state of Florida and the Tampa Bay area, and in Kansas City, Missouri, when I started out back in 1995, I learned that being a lawyer requires a certain degree of toughness. But at the same time, you are often put in situations where you are dealing with the exceptionally vulnerable people of America. People who have either been injured or have suffered because of a major event in their life where legal counsel is now required. One of the most sensitive cases I've ever handled involved an individual family who had a life insurance policy denied because of allegations the individual who died had committed suicide. Now, this isn't a case I'm working on right now, but these things happen with some regularity. And it's not so much cases where it's obvious that the individual committed suicide, where they've left a note or there had been some kind of suicidal ideation made prior to the actual death. I'm talking about a situation where an individual dies under what appear to be suspicious circumstances. There is no note, and there's a dispute between the insurance company and the individual family now who needs the benefits of the life insurance policy, but that policy claim has been denied because there is some interpretation that the cause of injury was intentional. Understand something. If there were in fact suspicious circumstances surrounding the death of your loved one, the medical examiner would have been obligated to perform some kind of autopsy, or what is referred to in the trades as a post. Well, the reality is that medical examiners are only looking at the information that has been provided to them and could be accessible by a physical examination of the body. But at the same time, the medical examiner will oftentimes provide an opinion about whether or not they believe this particular injury was intentional. The most common way for this to happen would be someone who accidentally took too much of a medication and then died because of a consequence of it, or where there was an interaction in medication, or maybe an individual who, after an emotional moment, was seen driving quickly in an automobile. The thing I want you to understand about medical examiners is when they say something is suicide, they're saying something different than perhaps what you or I would interpret as an intentional act. Instead, a medical examiner can call something intentional simply because the individual provided some piece of the puzzle, some conduct or act that ultimately led to their individual death. The thing I want you to know that's the most important is that individual decisions about whether a death is suicide for purposes of a life insurance policy can involve the decision of the medical examiner. But the findings of the medical examiner are never considered absolute or final. Instead, before an insurance company denies a life insurance policy, they must conduct their own investigation, and that should include things such as interviewing family members, reviewing the medical examiner's report, but also gaining access to all of the medical records of the individual who has died so that we can have a complete evaluation as to what the intent of the individual was prior to their death. Because the issue of intent will ultimately be decided by a jury of the individual's peers. If your family has suffered as a result of an insurance company denying a life insurance policy for any reason, please go to our website at www.corlissbarfield.com to learn more, or give us a call so we can meet and talk about what options you may have. I look forward to hearing from you.